of law. After I did my same-day video on President Trump's indictment and arraignment, I was pleasantly surprised to see President Trump reference the same case of Bill Clinton's from 2012.
Charging a former president of the United States under the Espionage Act of 1917 wasn't meant for this. An act for a crime so heinous that only the death penalty would do, and threatening me with 400 years in prison for possessing my own presidential papers, which just about every other president has done, is one of the most outrageous and vicious legal theories ever put forward in an American court of law. The Espionage Act has been used to go after traitors and spies. It has nothing to do with a former president legally keeping his own documents. As president, the law that applies to this case is not the Espionage Act, but very simply the Presidential Records Act, which is not even mentioned in this ridiculous 44-page indictment. Under the Presidential Records Act, which is civil, not criminal, I had every right to have these documents. The crucial legal precedent is laid out in the most important case ever on this subject, known as the Clinton Socks case. You know what that means? After leaving the White House, Bill Clinton kept 79 audio tapes in his sock drawer. They included discussions of U.S. military involvement in Haiti, discussions of U.S. foreign policy, both defense and offense, against Cuba, recordings of President Clinton's conversations with all of the many foreign leaders at the time. Think of that. Sensitive facts about trade negotiations taken from presidential briefings, discussions with the Secretary of State about conflict in Bosnia, and much, much more. Very big stuff. Not only was Bill Clinton never even considered for criminal prosecution based on the tapes he took, but when he was sued for them, he won the case. Judge Amy Berman Jackson's decision states, under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term and in the president's sole discretion. You're surprised to hear that, aren't you? Any normal administration, even an opposing one, would consider that to be the end, but not the corrupt Biden administration. The Sox decision, as it's known, also states, quote, the National Archives and Records Administration, or NARA, does not have the authority to designate material as presidential records. They don't have the authority. NARA does not have the tapes in question, and NARA lacks any right, duty, or means to seize control of them. This is law. The president enjoys unconstrained authority to make decisions regarding the disposal of documents. That's unconstrained to make that decision. Neither the archivist nor Congress has the authority to veto the president's decision. The Presidential Records Act does not confer any mandatory or even discretionary authority on the archivist to classify records. Under the statute, this responsibility is left solely to the President of the United States. Think of that. That's the decision. Think of that. Now, just think of that. In other words, whatever documents a president decides to take with him, he has the right to do so. It's an absolute right. This is the law. And that is something that people have now seen, and it couldn't be more clear. They ought to drop this case immediately because they're destroying the country.
Judicial Watch Incorporated versus National Archives and Records Administration. The lead lawyer for Judicial Watch's lawsuit against former President Bill Clinton on his documents, just completed an instant op-ed at the Wall Street Journal. Trump's boxes and Clinton's sock drawer. Although the indictment against Donald Trump doesn't cite the Presidential Records Act, the charges are predicated on the law. The indictment came about only because the government thought Mr. Trump took records that didn't belong to him, and the government raided his house to find any such records. This should never have happened. The Presidential Records Act allows the president to decide what records to return and what records to keep at the end of his presidency, and the National Archives and Records Administration can't do anything about it. I know because I'm the lawyer who lost the Clinton sock drawer case. The White House made the audio tapes between historian Taylor Branch and President Bill Clinton. The National Archives and Records Administration was never given the recordings. As Mr. Branch tells it, Mr. Clinton hid them in his sock drawer to keep them away from the public and took them with him when he left office. My organization, Judicial Watch, sent a Freedom of Information Act request to NARA, the National Archives, for the audio tapes. The agency responded that the tapes were Mr. Clinton's personal records and therefore not subject to the Presidential Records Act. Wow, what a difference from the National Archives going from President Clinton to President Trump, where the National Archivist set in motion a raid on Mar-a-Lago last year. I guess when you're a Democrat president, the National Archivist thinks of you differently than when you're Donald Trump. Back to the article. We sued in federal court and asked the judge to declare the audio tapes to be presidential records, and because they weren't currently in NARA's possession, compel the government to get them. In defending NARA, the Justice Department, this is in 2012, argued that the NARA didn't have a duty to engage in a never-ending search for potential presidential records that weren't provided to the National Archives by the president at the end of his term. Nor, the Justice Department asserted, does the Presidential Records Act require NARA to appropriate potential presidential records forcibly. Wow, what a change when it's Trump, right?
No person is above the law in this country. Nothing stops us.
Even a former president.
I don't know how to, maybe I'll say that again. No person is above the law in this country.
The government's position with a Democrat bureaucracy in 2012 was that Congress had decided that the president and the president alone decides what is a presidential record and what isn't. He may take with him whatever records he chooses at the end of his term. This is in 2012. Judge Amy Berman Jackson agreed. Since the president is completely entrusted with the management and even the disposal of presidential records during his time in office, she held, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. This is settled law, folks. It has not been challenged in the 11 years since this judge's ruling on behalf of President Bill Clinton. Judge Jackson added that the PRA, Presidential Records Act, contains no provision obligating or even permitting the archivist to assume control over records that the president categorized and filed separately as personal records. So even though President Clinton had all these discussions of top secret matters, war plans, and discussions with heads of state over all these different countries and plans that came up in his presidency, the judge said this was his personal property because the Presidential Records Act always determined that it was by the president's sole discretion, not the National Archivist, not Merrick Garland, not the Department of Justice, not Congress, not Joe Biden, not Special Prosecutor Jack Smith. None of these people could make this decision except the president. Same for President Clinton, same for President Trump. He continues, I lost because Judge Jackson concluded the government's hands were tied. Mr. Clinton took the tapes and no one could do anything about it. The same is true with Mr. Trump. Although he didn't keep records in his sock drawer, he gathered newspapers, press clippings, letters, notes, cards, photographs, documents, and other materials in cardboard boxes. Then Mr. Trump, like Mr. Clinton, took these boxes with him when he left office. As of noon on January 20th, 2021, and this is the law, whatever remained at the White House was presidential records. Whatever was taken by Mr. Trump wasn't. That was the position of the Justice Department in 2010 and the ruling by Judge Jackson in 2012. A decade later, the government should never have gone searching for potential presidential records. He means by the illegal FBI raid on Mar-a-Lago, Trump's home, nor should it have forcibly taken records from Mr. Trump. The government should lose U.S. versus Trump. If the courts decide otherwise, I want those Clinton tapes. So the central question of Special Agent Smith's indictment and fingerprinting of former President Trump is, why didn't the current special prosecutor in 2023 make any reference to the Presidential Records Act in his indictment? He must know that he and the Department of Justice are against the law, and that's why they must ignore established law, settled law, regarding presidential records. Listen to these two paragraphs from a similar Breitbart article. DOJ is certainly familiar with the Clinton Socks defense. Moreover, there are parallels between the two cases in that both former President Clinton and Trump allegedly disclosed classified information in private meetings. Special Prosecutor Jack Smith's indictment of Trump also relies on audio recordings of an interview between Trump and a writer and publisher. In the Clinton Socks case, which I just read to you, the tapes contain troves of private interviews conducted with historian Taylor Branch while Clinton was in office that illegally recorded phone calls and discussions Clinton had as part of his official duties. The court's opinion in the 2012 Clinton Socks case states that the sole authority to classify records pursuant to the Presidential Records Act rests solely with the President, and that the National Archives does not have any authority regarding classification, nor can it seize presidential records, precisely as the National Archivist, signed off on by Joe Biden, our president, did in 2022 in the FBI Mar-a-Lago raid. The Clinton Socks defense was just one of the arguments Trump cited. He also noted, as conservative radio host Mark Levin has pointed out, that the Espionage Act of 1917, which Trump is accused of violating and not violating the Presidential Records Act, was not intended to apply to presidents. If it had been, then every president who took documents with him before the passage of the PRA in 1978 could have been prosecuted for espionage. Now remember, folks, think back to 1978. Richard Nixon had been pardoned by President Ford, but Nixon took lots of presidential records home to San Clemente, California, in order to write his memoirs. Every single Democrat lawyer in Washington, D.C., in the federal government, and across the country would have jumped at the chance to prosecute President Nixon under the Espionage Act, not for Watergate, but for the additional crime, if it really was a crime, of taking these presidential papers home. Nobody charged Richard Nixon guilty of Watergate with the Espionage Act for taking these papers home. Why? Because no Democrat in the 70s believed they could reasonably convict President Nixon of the Espionage Act. What has changed from 1978 to 2023? I'll tell you what's changed. Today, in 2023, powerful federal bureaucrats like Merrick Garland, Special Prosecutor Jack Smith, and all the rest of the Democrats in the federal bureaucracy believe that power justifies all, and that their power makes the Democratic Party like gods who are above the law, and if the law doesn't fit what they need, they can twist the law and create new law to get Trump. That's what Donald Trump faces. The rule of law is what's at stake here, and the law has always been on Trump's side. When you have Special Agent Prosecutor Jack Smith, appointed by Merrick Garland and President Joe Biden, deliberately ignoring established settled law over the Presidential Records Act, you know that they know the law is not on their side. The Presidential Records Act is not a theoretical law waiting to be tested in some courtroom. It's already been tested in the courtroom and ruled in 2012 by a federal district judge as good, settled law, the law of the land. Democrats spent decades, especially under President Obama, telling us that you couldn't challenge settled law because that was their position under President Obama. But there are no rules when trying to get Donald Trump in handcuffs and get him behind bars. This is the lawlessness of the Biden administration, and the law says so. Thank you.